we were amending a trust instrument where we wanted to specifically include some additional beneficiaries for tax planning purposes. The deed allowed you to include other beneficiaries, but only if you did a formal variation, which again is not particularly unusual. We asked for a copy of the previous variations. We asked for a summary of the previous distributions. There had been many, many distributions made to beneficiaries that had been purportedly inserted into the trust instrument, except there was a no-no clause. So all of these purported insertions of potential beneficiaries did not have the appointor consenting to their insertion. All of the variations were void. And the question is, well, who's going to actually care about that? Well, our argument to the advisor here was, well, the main person that's going to care is the taxman. The second most person that's likely to care about this will be a disgruntled beneficiary saying, well, all of those distributions are in fact void. They're dragged back into the trust. The trustee is personally liable, and suddenly you've got an absolute riot on your hands because you haven't read the deed in its entirety. Why some deed providers would have it in their mind that they would want to bury that type of clause in an unrelated part of the trust instrument is beyond me. Most providers these days that require appointor/principal consent to a variation will do the decent thing, and that is actually have that in very obvious terms in the actual variation power itself. But on our checklist, we've got beware of the oh no clause, and would encourage you to have that on yours as well.